The United States' Second Amendment is possibly the most controversial part of the United States' Bill of Rights, as it is the section that guarantees Americans the rights to keep and bear arms. Now, no such explicit declaration exists in the Canadian Charter of Rights and Freedoms, and some Canadians consider that a good thing. However, I believe that there is actually an implicit right within the Canadian Charter of Rights and Freedoms for Canadians to keep and bear firearms specifically for the purpose of self-defense. Now, before I get into my argument, I want to address a couple of other arguments that are brought forward in regards to the right to own firearms in Canada. Now, one such argument goes back to the English Bill of Rights of the 1860s, in which it guarantees Protestants the right to own firearms, or arms rather. And my issue with this is, for one, it's the English Bill of Rights, not Canadian. It is from a foreign country. And while our legal system is based on the British legal system, it does not mean that English law is necessarily applicable in Canada, and that is a good thing. The other issue with this is that it guarantees the rights only to Protestants, and it guarantees the rights only subject to law. So already inbuilt in this Declaration of Rights is an escape clause that allows the government to enact restrictions upon an individual's right to bear arms. The other argument centers on a section of the Charter of Rights and Freedoms, Section 26. And Section 26 of the Charter reads, "The guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights or freedoms that exist in Canada." Now, people will use this argument to state that just because it's not explicitly declared in the Charter doesn't mean it's not a right. There's one big issue with this. Well, there's a couple of big issues with this, actually. For one, I am actually of the opinion that if a right is not explicitly declared, it doesn't exist. And I will get into why I believe that philosophically, hopefully in a later video. The other one is that you would have to have a judge agree with you that there is somehow an inherent right to own arms for the purposes of whatever you are trying to get the judge to agree with you upon. And it has already been established through case law when the government of Alberta sued the federal government in an attempt to get out of the Firearms Act that there is no explicit right to own firearms in Canada in the ways that have been previously put forward, and that the federal government has the sole purview of control of firearms. So Section 26 is not exactly the best argument to be using either, because it is a very shaky argument to begin with and relies heavily on having a judge agree with you that there is somehow an inherent right to bear arms, which in Canada you would have a very difficult time to do. Now, as I just mentioned, that previously the Supreme Court ruled that there is no right to bear arms in Canada. As far as I know, the way I believe it, this method has not been challenged in court yet, which means that we cannot say for sure 100% that this method is or is not applicable. And this method, or this way of justifying the right to own firearms in Canada, comes from Section 7 of the Charter of Rights and Freedoms. Now, in my previous video I talked a bit about it, but I'll mention it again. Section 7 reads that everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice. So how does that guarantee people the right to own firearms, specifically for the purpose of self-defense? It hinges largely on the availability of firearms in the criminal market. Since we are guaranteed the right to security of the person especially, and the right to life, those are the two most relevant sections to this argument. If a criminal can possess a firearm and an individual cannot, how could the individual guarantee their own security of the person against the criminal? Most people will say, call the police. The thing is, case law already has dictated that police do not have an obligation to protect individuals. When police say that they are there to protect you, they are referring to you in the plural sense, putting themselves above the general population. And by protecting, they mean protecting the general population by catching a criminal after a crime has already been committed. Now, on the microscopic level of an individual, that means that you first must become the victim of a crime before the police will help everyone else, not become victims of a crime by catching the criminal who committed a crime against you. What this means is that you are solely responsible for your own safety, and the guarantee of your own security of the person. Since criminals do have access to firearms in this country, and as long as there are firearms in the United States, they will continue to have access to firearms in this country, it stands to reason then that in order to be able to adequately respond to the threat of criminals taking violent action against an individual's security of the person, that individual should be guaranteed the right to possess at least the same kind of weaponry that criminals can possess in order to be able to adequately defend themselves against that weaponry. It is, in essence, an equalizer. Since a criminal has a firearm, if you have a knife, you are actually at a disadvantage, despite the fact that, yes, there have been studies done that show that a knife within 27 feet will beat someone from drawing a firearm. However, when a criminal breaks into your house, chances are their firearm is already drawn, already pointed at you, and in such a case, if you start charging with that knife, it's not going to do you any good. But in the event that you have a firearm present in such a situation, it does bring a great deal of equalization to the situation. And as a matter of fact, in the United States, most offensive gun uses don't even involve the discharge of the firearm. Simply presenting that fact that you have the ability to protect yourself from the criminal is enough to de-escalate the situation. Now, that is essentially the belief on the right to the security of the person. There is also the right to life. The inherent belief in pointing a firearm at an individual is you are threatening them with death. And in doing so, you are threatening their right to life. You are violating their constitutional right to life under Section 7, because you are threatening to end that right to life. Now, people will say that, of course, the criminal has a right to life as well. And that is where the latter part of Section 7 comes in, except in accordance with the principles of fundamental justice. Now, we already know that self-defense through case law is legal in certain circumstances in Canada, even up to and including lethal force with a firearm. We've been shown through cases like the example of Mr. Ian Thompson in Ontario, where the Crown actually dropped all charges related to the use of the firearm, and instead went after him for unsafe storage, because they knew that existing case law proved that what he did in discharging his firearm to scare away attackers was well within his rights for the purpose of self-defense. It's just that the government does not believe you can explicitly purchase a firearm with the explicit purpose of using it to defend yourself. So we already have established case law that it is legal to potentially kill someone if they are threatening your life, which means that the violation of the criminal Section 7 rights is already justifiable, because the criminal is committing a crime. In general, the philosophical belief is that when an individual commits a violation of someone else's rights, that is where their rights themselves end. Your rights end where my rights begin. And that is the belief with these criminals, is that if they are threatening your right to life, they have sacrificed their own, because they are putting such a heavy weight on the line there by threatening your life, that if you have to respond in turn in ending their life, that is considered entirely reasonable, and that criminal has sacrificed their right to life by threatening yours. They have also sacrificed their right to security of the person by violating your right to security of the person. We can see this as well with the justification for police being allowed to shoot individuals who are threatening themselves and threatening the public. Otherwise, that would be considered a violation of the individual's Section 7 right to life. But because they are threatening the right to life of others, by doing so in a criminal manner, in accordance with the principles of fundamental justice, ending their life is justifiable. And therefore, the infringement upon their Section 7 right to life is also justifiable. This means that in Canada, not only should you have the right to defend yourself because they are violating your security of the person, and you should have that right to protect your security of the person, but you also have the right guaranteed to you through the protection of your life. The criminal does not have those rights because they have sacrificed those rights by committing a crime against you. Now, some people go and say, if this is such a strong argument, or if this is the case, why doesn't it exist in law yet? And the reason for that is because in order to get it challenged would be a very difficult situation. Either you would have to have someone who is an otherwise law-abiding licensed firearms owner who carries their firearm illegally, preferably after having tried to go through legal avenues to get a concealed carry permit, because they do exist in Canada. They are just very rarely ever issued. There's less than 1,000 of them that have been issued throughout the entire country. So while they do exist, they are rare. Now, they would have to go through the legal avenues to get such a permit, be denied the permit inevitably, carry the firearm regardless, and be forced to use it, then try and argue before the judge that laws preventing them from carrying their firearm are unconstitutional and a violation of Section 7, which is a very difficult situation to get yourself into, because essentially you make a martyr of yourself, and in the event that the judge decides against you, you go to prison. The other thing is, you can bring a general constitutional challenge forward before the Supreme Court, but that of course takes a lot of money and time. Money and time that a lot of people don't have. Money and time that Canadian gun rights organizations also don't have. So while I do believe that there is actually a right to own firearms in Canada, specifically for the purpose of self-defense, I do not believe that such a right will ever be recognized by the government, because such a right being recognized by the government would take a very complex legal battle, one that I don't think is ever realistically going to happen. Now, if you want to learn more about firearms and gun control in Canada, I'll be providing some links in the description to several gun rights and gun control organizations. Now, as I said, I believe in exposing your own biases, so I will state that I am a member of 2 gun rights organizations in Canada. However, I want to make explicit my opinions are that of myself only. I am merely a member of these organizations. I am not authorized to speak on behalf of them. I am not an executive within them. There are thousands and thousands of Canadians who are members of these organizations. So do not construe my opinions with those of any organization other than me. And that is why I will not state which organizations I am a part of, is so that people cannot attempt to construe my beliefs with those of an organization that I have paid to be a member of. Now, Canada has 3 primary gun rights organizations. They have the National Firearms Organization, or the National Firearms Association, sorry. They have the Canadian Shooting Sports Association, and there is the Canadian Coalition for Firearms Rights. Every one of these fulfills a different purpose. The Canadian Coalition for Firearms Rights generally tends to work in public outreach and media. The Canadian Shooting Sports Association tends to work on the legislative side, working with politicians, and the National Firearms Association kind of does a mixture of both. They they're kind of from a different part of the country. The CSSA was founded in Ontario, whereas the NFA was founded out west, so they kind of existed at the same time in different areas. There are several also Canadian gun control organizations. The most notable ones are Police et Souvient, which is an organization founded, we remember Polytechnique, essentially, which the École Polytechnique shooting of 1989 was what spurred on much of Canada's gun control legislation. They are a largely French-based organization, mostly based in the province of Quebec, but nevertheless, they have significant influence within Parliament Hill and within the enactment of gun control legislation. The largest Canadian gun control organization, and one that actually has multiple links on their website that you can check through for other gun control organizations, because there are far more of those in Canada than there are gun rights organizations. That organization is the Canadian Coalition for Gun Control. And that has been an incredibly influential organization in the enactment of the current gun control legislation in Canada. As I said, I'll be providing links in the description below to all of these organizations so that you can do your own reading and form your own opinions. Because I do believe that that is the best course of action. I simply provide one opinion. I do believe that people should look at both sides of an argument when one is presented and form their own opinion based on the evidence provided from both sides of these arguments. Thank you for watching this video. I understand that while I said in my previous one I didn't want to be too late on getting videos out, and this is now 2 weeks late. So I apologize for that. Again, I shot this whole video in one take, no editing, no nothing, so if it's not quite up to the same kind of quality, if I stutter or pause a bit more than in my other videos, I apologize, but that is the reason for that. Again, if you like this video, if you have anything to add, any comments, questions, criticisms, anything like that, feel free to leave them in the comments section down below. I am Chris the Canuck, and thank you very much for watching. My next video, I hope to talk about why it is possible for someone to believe in the principles of freedom of speech, but to oppose speech that incites violence as being a violation of an individual's rights, and why it is not contradictory for someone to say they support free speech, but do not support threatening speech. And again, I hope to have that video out sometime, hopefully not with too much delay. Again, thank you very much for watching.